everyone. We are waiting on a couple of members to arrive. However, we're going to begin, respectful of our witnesses, one of whom has a hard stop. I know we have votes scheduled at about 1:30. So we're going to move forward. I recognize myself for the purpose of making an opening statement. Today, the subcommittee is going to hear about the aggressive enforcement tactics employed by the Environmental Protection Agency and the Department of Justice to intimidate small businesses into consent agreements and other enforcement actions. Today's hearing focuses on one specific issue: the overly aggressive enforcement tactics, many of which are better suited for hardened criminal enforcement, used by the Biden administration to intimidate hardworking small business owners and set an example through regulatory terror against everyday American entrepreneurs. The Clean Air Act clearly provides the EPA with criminal enforcement authority. Like it or not, Congress granted the EPA that authority. What is in question is whether the agency, which has seen its enforcement program shift from prosecuting industrial polluters to persecuting small businesses, the question is whether or not they have fairly and consistently applied its use of criminal authority, or if enforcement actions under any administrations were hypercharged in pursuit of left-wing political objectives under the so-called banner of environmental justice. In the 1990s, Congress expanded the EPA's criminal authority. However, shortly after enactment, the EPA conceded it has limited criminal authorities. In an internal 1993 EPA memo, EPA enforcement personnel concluded that Congress intended criminal responsibility of an owner or operator to be strictly limited to, quote, senior management or corporate officers, or the Clean Air Act violation was of a knowing and willful magnitude of intent. That memo went on to state, quote, automobile dealer or repair shop tampering with automotive air emission systems still cannot be prosecuted criminally under the CAA, since the mobile source regulations impose various compliance certification responsibilities only on automobile manufacturers and not on the dealers. Over time, the EPA's enforcement focus has clearly shifted. Instead of pursuing massive industrial polluters who employ highly paid legal defense teams, EPA, under the Biden administration, chose to focus on mom-and-pop shops, and with those shops had limited means to argue their case against the legal might of the Department of Justice, backed by the EPA. Often, the EPA's enforcement actions involve raids on shops by teams of armed EPA agents who intimidated small businesses with threats of criminal prosecution. If achieved, these prosecutions would deprive targeted individuals of their right to vote, their Second Amendment rights, not to mention the destruction of their businesses. As a former law enforcement professional, I question why the EPA even has the authority to have armed agents raiding Americans' homes and workplaces for alleged violations that are often highly technical, regulatory violations, alleged regulatory violations, with no suggestion of any threat of harm or violence to law enforcement. It's a legitimate question Americans should ask. Why are these raids even happening in a regulatory environment? There are plenty of other law enforcement resources at the state and local level that, when truly appropriate, if the EPA felt that they needed that kind of help, they could employ to help execute a warrant. But what is clear is that the use of armed EPA agents is not motivated by public safety. Rather, such heavy-handed tactics are clearly aimed at intimidation, have a regulatory focus and purpose backed by a political agenda, and they drive that message home very clearly when they hit a home or a business at 0:30 and terrorize the business owners and the families. For this reason, the subcommittee has conducted a thorough review of all regulatory agencies' quote-unquote badge and gun authority to determine if rogue administrative agencies need their authorities curtailed under any administration. The Obama administration, the Biden administration, President Trump's administration. Regulatory authority is regulatory authority. But terrorizing Americans is a bridge too far. I fear the EPA's aggressive use of its criminal authority proves the adage, quote, power tends to corrupt, and absolute power corrupts absolutely. Madam Ranking Member, I would like unanimous consent to enter a letter dated April the 11th, directed to Honorable Pam Bondi, the Attorney General, Department of Justice, and the Honorable Lee Zeldin, Administrator of the EPA. Without objection, I now recognize the Ranking Member, Ms. Lee, for the purpose of making an opening statement.
Thank you, Mr. Chairman. Enforcing our environmental laws is critical to protecting public health and ensuring that every person in this country has access to clean air, safe water, and healthy land. When EPA enforces the law, children can breathe without inhalers or drink water without lead and play outside without fear of developing rare cancers. I recognize that navigating the EPA regulations isn't always straightforward, especially for small businesses. But complexity does not make these protections any less necessary. Defeat devices are banned because they cause real harm. More asthma, more respiratory disease, more premature death. The solution to confusion is not to weaken protections, but to ensure the EPA has the staff and the resources to give businesses the guidance they need, protecting both public health and businesses from liability. But under the Trump administration, the EPA has abandoned its responsibilities. Workers have been laid off. Funding has been withheld. More than 160 corporate enforcement cases have been dropped. And instead of focusing on the largest polluters, enforcement has too often relied on criminal penalties against small players. At the same time, Trump has dismantled the EPA's Environmental Justice Office as nearly 200 staff laid off or pushed out. In March, EPA stopped considering environmental justice altogether in enforcement decisions. A former EPA staffer warned that without those staff on the job, the air we breathe and the water that we drink are at a greater risk from toxic pollution that causes cancer, asthma, and lung disease. EPA has stopped accepting new civil rights complaints or issuing findings of discrimination under Title VI of the Civil Rights Act. 13 complaints are now in limbo, including one over poultry waste polluting Black and indigenous communities in North Carolina. Families living next to refineries and highways are being told their health doesn't matter. So let's be clear. And the only persecution we should be talking about is what Black and brown and poor families have endured for generations. Families forced to raise their kids in the shadows of smokestacks. Children that are twice as likely to die from asthma. Communities where cancer rates soar beyond the national averages. And a government that continues to turn its back on them. The Trump administration's actions are alarming and abhorrent, but I would be remiss not to note the absurdity of this hearing. If this subcommittee on federal law enforcement were serious, we'd be examining the most lawless administration in modern history, one that is illegally withholding congressionally appropriated funds, dismantling federal agencies, firing watchdogs, deploying troops into American citizens, and withholding documents about one of the worst child sex traffickers in history. Just outside of these walls, Washington, D.C. is still under federal occupation. But instead, we're here having a hearing focused on the past, talking about, quote, weaponized environmental enforcement, while the current right now administration dismantles all of our environmental protections to the detriment of our air, our land, our water, our health, and yes, our people. I yield back.
Gentlelady yields back. We have a member waving on to the subcommittee without objection. Representative Grothman of Wisconsin is waved on to the subcommittee for the purpose of questioning the witnesses at today's subcommittee hearing. I'm pleased to welcome our witnesses for today. Mr. Corey Willis is the owner of Power Performance Enterprises Incorporated, or PPEI. Based in Louisiana, PPEI is a leader in automotive performance tuning. Mr. Justin Savage is a global co-leader of Sidley Austin's environmental health and safety practice and co-leads the firm's automotive and mobility sector team. Mr. Eric Schaefer is the former executive director of the Environmental Integrity Project. We look forward to hearing what you have to say on today's important topic. Pursuant to Committee Rule 9G, the witnesses will please stand and raise their right hands. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses all answered in the affirmative. Thank you, and you may be seated. We appreciate you being here today. We look forward to your testimony. Let me remind the witnesses that we've read your written statement, and it will appear in full in the hearing record. Please limit your oral statement to 5 minutes. As a reminder, please press a button on the microphone in front of you when you need to speak so that it's on and the members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. When the red light comes on, your 5 minutes have expired, and I ask you that you wrap up. I now recognize Mr. Corey Willis for his opening statement.
Chairman Higgins, Ranking Member Lee, and members of the subcommittee, thank you for the opportunity to testify today. It is a privilege and an honor to be here, and it is by the grace of God that I'm able to be here today. My name is Corey Willis, and I own Power Performance Enterprises Incorporated, better known as PPEI. I love God, my country, and my family. I want to share what I've experienced during the past decade since the government started prosecuting me and my company, culminating in a civil consent decree in 2022. I walked at 11 months and I was placed on my first Fuller 1 month later. I quickly learned the fastest way to get from point A to point B was not walking, it was machines, leading me to eventually start PPEI when I was 19 years old. PPEI started as a company that specialized in high-performance tuning of vehicles for racing, and interest in our products grew as it became evident that diesel vehicles with the original manufacturer emissions control devices were failing. Regular guys like me had to choose between fixing their cars or enjoying a vacation or dinner out. My tunes solved their problems and in fact made their cars drive more efficiently. It also took off for others who wanted to see their everyday cars go faster. The journey with the EPA started on my 25th birthday, November 3rd, 2015, almost 10 years ago, when I received a request for information from the EPA. We forwarded it to the attorneys to handle, for me thinking it was a formality and essentially not a big deal. I had no idea the EPA was making a change in their enforcement priorities to include our industry practice. In the years following that information request, my family and I spent several $1 million in legal and accounting fees, and hundreds of, even thousands of hours of staff time responding to the EPA's demands and trying to understand EPA's position on the sales of our company's tunes. We tried to differentiate certain aspects of our business, including related to military and emergency vehicles and off-road or competition use, all of which are supposed to be not subject to the strict federal emission standards. The propaganda machine has led many to believe that combustion engines are far more harmful than they really are. We scrambled to try to come to agreeable terms regarding what we could and could not sell and the appropriate penalty. This was a massive undertaking by our legal team and staff. For example, one of our document productions was 44,000 pages. At one point during the civil consent decree negotiations, EPA demanded tens of millions of dollars to resolve the matter. I had nowhere near the numbers that they proposed, and for this, we fought for years. In the spring of 2019, EPA and DOJ civil enforcement attorney advised that, in short, we could either stop selling any products or go to court. Going to court was not a viable option due to the cost and the stress it would have on my entire family. In August of 2020, family and friends' homes were all devastated by Hurricane Laura and then pounded again by Delta in October. My offices were demolished. We were struggling for survival. We were fighting insurance companies to cover damages. We were trying to figure out where we were going to work, and our employees were displaced. The EPA was demanding my time while I was rescuing people and cutting trees off the roofs of people's homes, literally orchestrating 18-wheeler loads of water and other essentials at my ripped-apart office, and we were doing this for search and rescue teams also. Many of the members of these teams even stayed at my house while I had holes in the roof. Our record-setting diesel drag program fell apart due to the hurricanes and continuing demands related to the EPA investigation and prosecution. People matter more than business, so while my attorneys were scrambling to respond to requests from the EPA for information, I generally just tuned out the legal storm that was building around me to focus on recovery from the hurricanes that had devastated us. I never gave up on my business or my employees. I kept them on the payroll during COVID while myself and other senior employees donated our paychecks back to the company. I worked with them to build our business back and all of our livelihoods, and I'm speaking out now because I don't want to see this type of confusing and overbroad agency enforcement impact other people the way it has impacted us. On May 22, the consent decree was finalized. We simply did not have the money to fight the endless resources of the federal government, and the DOJ's overly burdensome requests would have continued to plague my family and business. While there was so much in the consent decree that I preferred to be different, it was not in my best interest to keep fighting since negotiations had been going on for about 7 years. I believed then that the consent decree offered to PPI and me were our best option. I was hopeful that despite the restrictions imposed, we could keep PPI afloat, allowing me to continue to keep paying me and my staff and continue doing what I love. But the consent decree immediately impacted PPI, putting it at a disadvantage. PPI was losing money and forced to lay off employees. For us to get our products to market, the consent decree required us to obtain executive orders issued by the California Air Resource Board, or CARB. We would have to obtain a certificate within 2 years or stop selling our products. Previously, California had regulations that we could work with, but it is no longer that way. It will take me decades to recover from the nightmare we have all gone through. I want to thank you all for the opportunity to speak today.
Thank you, Mr. Willis. I now recognize Mr. Savage for his opening statement.
Good afternoon, Chairman Higgins, Ranking Member Lee. Oh. There you go. Good afternoon, Chairman Higgins, Ranking Member Lee, and members of the subcommittee. Thank you for the opportunity to testify today in my personal capacity. The views I share are my own. My name is Justin Savage. I'm a partner in the law firm of Sidley Austin, where I co-lead our environmental team and I co-chair our global auto group. I practiced law for 29 years, including nearly a decade at the U.S. Department of Justice, where I represented EPA enforcing our nation's environmental laws. Before turning to my testimony, I wanted to mention that I am proud to appear before your subcommittee, Mr. Chairman, because my daughter Caitlin was born in Lake Charles, and my wife Amy and I, who's here today, graduated from McNeese State University there. I'm here today to focus on the surge of criminal environmental enforcement against small automotive industry players for check engine light violations, also called onboard diagnostic or OBD tampering, the lack of statutory authority for these prosecutions, and the impact of this weaponization on small businesses and individuals. As President Trump and EPA Administrator Zeldin have said, economic prosperity and environmental stewardship are compatible. To accomplish that mission, we are blessed with many dedicated leaders and public servants at EPA and DOJ. The problem we have is that environmental enforcement can stray from its core mission, becoming a game of gotcha, where due process, fair notice, and proportional punishments are thrown out the window. As a defense lawyer, I've seen these excesses where EPA pursues small businesses that sell products and repairs for diesel pickup trucks. These are folks with previously clean records, many of whom have never dealt with EPA. Instead of reaching out to these small businesses to bring them into compliance if necessary, there's sometimes been a resort to heavy-handed tactics, including sending in armed agents. This happened to John Long, who is here today in the hearing room. John defended our nation as a member of the United States Navy for 20 years. In addition to serving in the Navy as a diesel mechanic, John had a small side business he ran out of his home garage to repair pickup trucks. John's first contact with EPA occurred when 10 armed agents pounded on the door of his family home at dawn, wielding a battering ram. That dawn raid on John's home escalated into 6 felony charges under the Clean Air Act for allegedly tampering with onboard diagnostics or OBD systems. Putting that into plain English for y'all, the government charged John for allegedly helping 6 pickup truck owners turn off their check engine lights. For decades, EPA considered this conduct to be a civil infraction, not a federal crime. EPA issued a guidance document in April 1993 during the Clinton administration, stating that the Clean Air Act did not authorize this kind of criminal liability. But EPA reinterpreted that statute to make it a crime to turn off a check engine light after Mr. John's conduct. We also have with us today 2 other victims of these kinds of prosecutions, Josh Davis and Aaron Rudolph. Just like John, they had clean records and no prior interactions with EPA. Both grew thriving auto businesses that employed dozens in Illinois, Florida, and North Carolina. And they gave back to their communities, with Josh serving as a Republican-elected member of the Woodford County Board of Commissioners, and Aaron most recently supporting rescue operations during Hurricane Helene. Yet EPA aggressively pursued Josh and Aaron for Clean Air Act compliance concerns over aftermarket products. Under the Biden administration, we saw a 9-fold increase in these kinds of baseless criminal prosecutions, often against small businesses. When you're faced with the threat of a federal criminal prosecution, many have no choice but to take a plea rather than risk their freedom. I was proud to defend John, Josh, and Aaron. Those criminal cases should have never been brought. EPA should not be allowed to move the legal goalposts and charge people with novel crimes, particularly small businesses. Let me conclude with this. There are ample civil enforcement authorities to address Clean Air Act compliance concerns, so we all have that clean air that we want to breathe and protect our families. The problem is the compliance path. As a condition of Clean Air Act civil settlements, EPA has frequently required businesses, as Corey mentioned, to obtain approval from the California Air Resources Board, which can be burdensome and costly. Instead, EPA should consider public-private partnerships, including voluntary certification processes for compliance, and the rules should be clear up front. Thank you, and I look forward to your questions.
We thank you, Mr. Savage. I now recognize Mr. Schaefer for his opening statement. Let me just add before you start, sir, before you start the clock, they're going to call votes here shortly. We're going to play that by ear. Mr. Schaefer, you're recognized.
Thank you, Mr. Chairman and Ranking Member Lee and members of the committee for inviting me here. I led the Environmental Integrity Project for 22 years before I retired last year. But before that, I was director of the Office of Civil Enforcement at EPA from 1997 to 2002. If you spend a few minutes online, you'll see a lot of businesses advertising products that promise to delete or disable emission controls or to disable the monitors that determine whether or not they're working. I've provided an exhibit with some of those where you can see some of those ads. Just to cite from one, it promises to unleash your truck's full potential with our complete full delete bundle. This all-in-one kit removes your entire emissions system. So these products are sold with a promise that they are going to remove or disable your emission controls on diesel trucks. That's a problem because that kind of tampering is prohibited by the Clean Air Act, but it's also very dangerous. EPA has estimated that trucks that have removed their pollution control devices released about 570,000 tons of nitrogen oxides into the air between 2009 and 2019. Those nitrogen oxides drive smog. You also get more diesel particulates, which are particularly hazardous and linked to cancer and heart disease. So getting these illegal and dangerous products off the market shouldn't be a partisan issue. I can't speak to the specific cases that have been discussed today, but I do want to make the point that the launching of this enforcement initiatives to crack down on the sale of these aftermarket devices started under the Trump administration in President Trump's first term. There are some online rumors that suggest that enforcement may stop altogether. I certainly hope those rumors are unfounded. So the Clean Air Act long ago required EPA to limit tailpipe emissions. That's to control, keep us from being smothered by smog and soot, which would otherwise happen if these vehicles didn't have to comply with emission control limits. The same requirements said that you had to install monitors to make sure that those pollution controls, those onboard systems, catalytic converters, particulate filters, were actually working. You have an onboard diagnostic system that lights up when your emission controls are faulty and won't turn off until the repairs have been made. So that's the alert that tells you your system, your pollution controls aren't working and you need to take the truck in. So whether we agree the standards are too stringent or not stringent enough, it surely makes no sense to require manufacturers to install pollution control systems and monitors to make sure they work, but then allow their companies to strip them out as soon as diesel trucks leave the dealer's lot. But that is happening. That is a real problem. It is a federal crime to tamper with monitoring devices. That is a position that, again, the Trump administration took in its first term. To its credit, it puts out lots of guidance, put out a lot of guidance when it launched the enforcement initiative, explaining that and insisting that there were potential criminal penalties. The same guidance documents offered incentives for companies to come in and voluntarily self-disclose. Federal courts have actually rejected the argument that the Clean Air Act doesn't apply to these aftermarket defeat devices, quoting, and that includes the monitoring systems that ensure they work. Quoting from one recent decision, 3 district courts have all gone the same way. The judge said, nothing in the text of the Clean Air Act suggests the statutes only apply to devices that monitor emissions. On the contrary, the statute covers any monitoring device or method that the Clean Air Act requires. That judge and others are citing the law, not EPA policies or interpretations. So, as I said, you get dangerous levels of emissions when these emission control systems are stripped out of trucks. People who live near highways or in neighborhoods that are crowded up against ports or construction sites get hit with a heavy load of these diesel particulates. They're most exposed. They don't have the resources to move or fight back. I know it's not fashionable to say this, but those folks are trapped in a classic textbook case of environmental injustice. So I just want to close by saying that I understand that the emission controls required by law require maintenance, and that can be inconvenient. But while a few diesel truck owners believe they may have the right to remove pollution controls and turn off monitors, most of them are complying with the law, and diesel trucks have gotten a lot cleaner. But speaking of rights, what about the rest of us? If you're stuck behind a diesel truck or a bunch of diesel trucks in a traffic jam and being showered with soot, live in an apartment next to a highway or in a city choked by smog, don't you have the right to breathe clean air? We used to think so. Thank you, and I'll be happy to answer any questions.
I thank the witnesses for their opening statements. We'll note for the record that the chair was quite generous with Mr. Schaefer's statement, over 6 minutes. Consult with the ranking member for Okay, I recognize myself for questioning for 5 minutes, and then very likely we're gonna break for votes, and not sure how long that will take, but we'll be back as quickly as possible. Mr. Willis, we're gonna be careful that, we're not trying to ask you questions that you're not able to answer, and it's my understanding that you're under some level of restrictions on how you can talk about your case. And if any of us up here ask you a question that you're not comfortable with, I do believe you have counsel present, is that correct?
That is correct.
Okay, so if your counsel needs to hand you a message or something, then we're going to allow that. And if you don't feel comfortable answering a question, perhaps you can defer to Mr. Savage or Mr. Schaefer if you feel they can respond to one of the members' questions. So prior to, you said your first notice, your first interaction with the EPA was a notice that you received in 2015. Prior to that, had you ever had interaction with the EPA? Had they come by your shop and told you, indicated you that maybe you're violating any regulations?
No, sir. We received the RFI on November 3rd, 2015.
Okay, and the request for information was regarding your sales, and that was your first indication that maybe the EPA was looking at you, is that correct?
Yes, sir.
Okay, and have you ever, in your business, I ask this respectfully, did you ever have any, like, tax issues with the IRS, or had the federal government ever indicated to you that you were doing business in a shady manner? Or describe your operations for us. Were they professional, documented? You pay taxes, et cetera?
Yes, sir. We've paid our taxes and clean books. No issues.
Yeah, that's my understanding. Just trying to clarify for the American people that Mr. Willis has squared away business. As far as he knew, he was following every law, state law. Later on, I did my best to help. And we were heavily involved, and we couldn't find anything that he had done wrong. It seemed like it was a targeted investigation and persecution. I didn't really want to believe that about my government, but it seemed that way. And they began enforcing, it seems like, if you can speak to this, Mr. Willis, California emission standards. Did you sell parts in California? What would happen if I was in California and I wanted to order one of your tuning kits?
Our website back then and still today, if you're in California, it doesn't allow full checkout.
Why not?
We don't sell to California.
Why not?
It's extremely difficult to do business in California.
Because do they have different emission standards?
Yes, sir. CARB standards.
So as a squared away business owner, you recognize that? You just didn't do business in California, correct?
Yes, correct.
Did the EPA use California standards to prosecute your civil case and your criminal case?
Our plea agreement requires us to utilize California standards.
But you didn't do business in California, did you?
No, sir.
Do you now?
We never shipped into
Have you ever?
California. No, sir. We've never shipped into California
Okay.
unless it got through.
Can you speak to how much the economic impact this had on you? Like, how much money did you end up paying to the EPA? Can you speak to that?
Yes, sir. It was in excess of $3.1 million.
Okay, how much have you estimated conservatively how much business you've lost over the last decade, you and your family?
Just the last 5 years on emissions compliant products, probably around 12 million, and then if we're talking full racing products, probably over 100 million.
And what have you? Can you speak to what you've paid counsel, what you've had to pay attorneys over the last decade?
Yes, sir. In excess of 7 million.
So you have an American family here that's talking about over $20 million, maybe a lot more. A squared away business that paid his taxes and, according to everything he knew, followed the law. And the EPA never invited them in and say, hey, we believe you may be in violation in this category. They went straight to prosecution. And when the weight of the federal government comes upon an American family, it's like lights out. It's very difficult for a regular American family to respond. You just get ground up in the gears of the federal government. That's what has happened. Mr. Savage, I hope to ask you questions later if we have a second round. Votes have been called, and we're going to go ahead and declare the committee in recess, subject to the call of the chair.
Everything okay so far?
Mr. Shea, I didn't get to greet you. Thank you for being here. Very professional, gentlemen. I disagree with you. Maybe we'll get a chance to talk. Mr. Savage and Corey, we'll be back 10 minutes after votes. You're talking about roughly 40 minutes. We'll be back. Yes, ma'am. Yes, ma'am. Okay, we'll be back. Let's get vote.